unexpected things.
It's alright.
So tak balik Penang lama.
Oh, lama tak balik because generally nobody Penang to go back to.
Oh, tak ada. Ya, okay.
Adik ramai lah.
Ya.
In the whole of Penang tadi adik.
Tak miss lah. Nasi kandar.
I'm not really inilah.
Oh, ya ke? Okay.
Mungkin miss jala kot.
Ya. Masya Allah. Alhamdulillah.
Penang, Prof.
I'm from Kampung Makam.
Oh, tu dia.
Adik Tajuddin. Nanti you know my brother Tajuddin.
Pak Allah Tajuddin ke?
No, this Tajuddin last time dia apa ni saman hantar saman panggil apa? Saman server.
Okay.
Tajuddin.
That's your brother. Also ada kena-mena dengan mahkamah juga lah.
Dengan siapa tu?
Mahkamah.
Yeah. Yeah, I did mention that last time when we met, Jakarta was my old friend. That Jahabatin.
Saya tengok muka kena kot. Tak jumpa kan?
Yalah, lama tak jumpa.
We'll start our session. Okay.
We can start.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh and a very good afternoon to our honorable speaker yang berhormat Datuk Sri Dr. Jahaberdin YM Muhammad Yunus and Evidence Law Lecturer Dr. Ismail bin Muhammad Yunus. Thank you for participating this event and thank you everyone for joining the Legal Practice Department Talk Series entitled The Relevance and Art of Cross-Examination. On behalf of I would like to sympathize and feel equally saddened by the fate that has befallen our fellow brothers and sisters affected by the floods. Let us together pray that things will return to normal in Malaysia. We hope that everyone is in safe condition and prayers to the people who are affected by the flood is always in our heart. Before I commence the session, I would like to invite Dr. Ismail bin Muhammad Yunus for the opening remarks.
MashaAllah. Thank you, Miss Moderator. So Alhamdulillah, we thankful Almighty Allah Subhanahu Wa Taala for giving us the tawfiq and hidayah. We'll be able to meet after the long preparation that we have made. Alhamdulillah. So before I begin, I would like to give one pantun lah. Mahatma Gandhi nama diberi, kepalanya botak berseri-seri. Hati kami girang sekali kerana Datuk Seri sudi hadirkan diri. Alhamdulillah. Thank you Datuk for spending some of your precious time with us to meet the old friend, to meet your brothers and sisters here. So may Allah Subhanahu Wa Taala consider your experience, your sharing moment with us as a part of Amal Jariyah. That will be very useful to all of us to continue the legal mechanism in order to establish justice. Alhamdulillah. So on behalf of Kuliah Ahmad Ibrahim Legal Practice Department, Ahmad Ibrahim Kuliah Law, we are really feel honored with your appearance together with us. So I hope that this is not the first and the last. Inshallah, we are going to have several more meetings and would like to share more of your wisdom with us. So thank you, Datuk, for spending time with us. May Allah bless you. Thank you.
Thank you. So there's an indication I can start, is it?
Ms. Moderator, anything else to say?
Can we introduce you?
Yes, please.
All right, thank you. All right, without further ado, I will commence the session today by introducing our honorable speaker yang berhormat Datuk Sri Dr. Jahaberdin bin YM Muhammad Yunus. Datuk Sri Dr. Jahaberdin bin YM Muhammad Yunus graduated with Bachelors of Laws from University of Leeds, United Kingdom in 1991 and further in Master of Comparative Law from International Islamic University, Malaysia in 2006. In addition, Datuk Sri obtained PhD in Social Science from Lincoln's University College in 2021. The PhD thesis entitled Malaysia Muslims Resilience to Islam Linked Terrorism Quantitative Analysis. As for publications, Datuk Sri has published various publications which includes economics textbook for upper secondary students, book entitled Islam Antara Isi dan Kulit, also book entitled Rapera Urgently Wanted. Datuk Sri also has published article entitled Examining Demographic Behavioral Differences Among Malaysian Muslims, Resilience to the Religiously Based Terrorism, a Quantitative Approach at TEST Engineering and Management in 2020. Next, Comprehending Muslim Resilience to Religious-Based Terrorism, a Literature Review at TEST Engineering and Management. Datuk Sri also is a columnist with Berita Harian writing on Islamic issues in 1999 to 2004, and currently also a columnist with Malay Mail and columnist with The Star, and also blogging at Jahar Berdin Blogspot on social, political, and Jahami Blogspot on religion and Islam. Datuk Sri also has involved in government appointment as investment panel member of Tabung Haji in 2016 to 2018, and also a special task force member of Bank Negara Forex Losses Investigation panel in 2017. Currently, Dato is a legal advisor of Royal Malaysian Polo Association, chairman of Legal Advisory, Disciplinary and Alternate Dispute Resolution of Olympic Council of Malaysia in 2021, and also a deputy president of Badminton Association of Malaysia. Further to that, Datuk Sri also received awards on Darjah Sri Sultan Ahmad Shah Pahang in 2016 and Darjah Indra Mahkota Pahang in 2010, and also Pingat Jasa Masyarakat Pulau Pinang, PJM in 2007. Thank you Yang Berhormat Datuk Sri for participating in this forum as our honorable speaker. On behalf of ICOR, we would like to express gratitude and appreciation to you. Without further delay, you can present. Thank you, Doctor.
Thank you, Ms. Moderator, for a very elaborate and long introduction. Thank you very much. It's good to see Dr. Ismail again. And Assalamualaikum to everyone. Okay, the topic I've been given, I think I'll just jump straight into the topic. Now, I assume that everyone who's listening here are students. Betul, Doctor, yeah?
Yes.
Okay.
Yes.
All right. So what I'm going to talk about is I'm going to talk about from the perspective of practicing. So the topic that's given to me is relevance and art of cross-examination in practice. So we should be looking at two aspects. One is the relevance part of it, and second is the art of cross-examination. Now, before we do that, we need to get things into perspective. So let's look at this in the first place. We must remember, I hope you remember throughout my talk here, that we are talking about what happens in the courtroom. So whatever that we studied in the universities, in the evidence books and the Evidence Act, we'll be implementing them in the courtroom. So what happens in the courtroom? Now, in the courtroom drama, there are always two sides, because in Malaysia, we have what we call an adversarial system. So on one hand, in the civil case, you have the plaintiff, and then you have the defendant. And in a criminal case, you have the prosecution and the accused. So essentially, the plaintiff will sue the defendant, the prosecution will prosecute the accused. So during the discussion, I will be jumping between both the civil and the criminal case, and wherever they are different, I will let you know what they are. Now, in the courtroom, these are the people who are acting. We must remember them also. You have first the judge, and he's a referee, because adversarial system, you have two sides, opposing sides. The referee is a judge. So in our system, it is designed in such a way that the judge behaves as though he does not know the case at all. He's hearing the plaintiff for the very first time. He's hearing the prosecution for the very first time. And likewise, hearing the defense lawyer for the very first time. So in the courtroom, what happens is, in Malaysia, we have a trial and we have an open system. Yeah? And I was just telling Dr. Ismail that I doubt whether or not these online hearings can amount to an open system under our law. So that's another debate for another day. But we always think that the purpose of a trial is to dispense justice. That is true. But the question is, how is this justice dispensed in the civil courts? Now, the only way justice can be dispensed in the court is through evidence. Remember, I said earlier that both the judge, both the prosecution and the defense, or the plaintiff and the defendant are appearing before the judge for the very first time. So the judge does not know the case. The only way the judge can know the case is through what is called evidence. And this evidence is led by both the prosecution and also by the defense. And there are two kinds of evidence. Very briefly, I'm sure you already mastered evidence law, but very briefly, there are two kinds of evidence. One is evidence which is oral. That means you go to court, you take the witness stand, you take an oath, and you talk. You say, pada pagi itu apa berlaku, pada semalam apa berlaku, saya lah pakar kimia, those kind of things. Or secondly, is by way of documentary evidence, documents, photographs, videos. These are all called documentary evidence. So it is very important to note, again emphasize, that the entire purpose of the trial is to dispense justice according to evidence. So evidence must be put into the trial in order for the judge to make up a decision either way. This I put a star there. Now, how is evidence adduced? Now, the entire rules of the game is inside this called the Evidence Act. I always tell my chambering students and my lawyers, and when I go and give talks to lawyers, I tell them that a good litigation lawyer must master, he must know the entire Evidence Act. After all, there's only 167 sections in the Evidence Act. So here, the Evidence Act itself tells you about how evidence can be adduced. Remember, I told you earlier that you have these players, the prosecutor, the defense lawyers. Okay. If you look at this, you have something called the examination in chief. Examination in chief is whatever evidence is adduced by the prosecutor. Evidence in chief is whatever evidence is adduced by the plaintiff. Meaning, whoever calls the witness, he adduces evidence. That is called examination in chief. So in a criminal trial, for example, you have the prosecution first, followed by the defense. So when it comes to defense stage, when the accused adduce evidence, that is called examination in chief. But today's topic is on the second one called cross-examination. So what happens, let's make it simple. Let's say you are the prosecutor. So you call your witness first, and you are getting evidence out of him. That is called examination in chief. Once you finish adducing evidence through your witness, you sit down. The defense lawyer will stand up and cross-examine the prosecution witness. In other words, evidence which is adduced, brought out through the defense lawyer of the prosecution witness is called examination in chief. And that is provided for in section 137 of the Evidence Act. You can have a look at it. Now, once the examination in chief is, once the cross-examination is over, he sits down. The defense lawyer sits down. Then the prosecution stands up again. Now, what he does now is he now tries to repair whatever damage the witness may have made. So this is how the flow goes. Now, again, I emphasize the entire rules are in the Evidence Act 1950. Now let's move to what exactly is cross-examination. Now, there are many ways of understanding, defining cross-examination. We already saw earlier, under the Evidence Act itself, they say that cross-examination is by the adverse party. You remember that? Eh? If your witness, I question, mine is called cross-examination. Your witness, you question, is called examination in chief. So here we say the questions asked by the defense lawyer to the prosecuting witness. Now, another way of understanding cross-examination is, which I like, which is usually my definition, is the art of arriving nearer to the truth by asking a series of logical questions. Now, why do I say that? My lawyers have heard me always say this, that human beings are, number one, boringly predictable. You can actually predict human behavior. In fact, a good litigation lawyer, after 20 over years in practice, is able to predict the answers a person is going to give. Why? No, wait. The other reason is human beings are often reckless and careless in their speeches. Let me give a very simple example. Yeah? we generally are not very systematic in our thinking. Say, for example, you ask a very simple question to somebody, your friend. Your friend just came back from lunch. You ask him, where do you go? He said, I went out for lunch. Our assumption straight away is that he must gone out to eat. Correct? So we assume that Ali went out to eat. So another person asks us, tadi Ali pergi mana? We say, oh, Ali, dia pergi makan. And later somebody meets Ali and say, Ali, what did you eat? Ali said, I didn't eat. I just went out for lunch. So therein, if you ask, if Ali comes and says, I went out for lunch, my question to him would be, did you eat? Now, to a normal person, it's like, what a silly question to ask. If you go out for lunch, automatically you must eat. But cross-examination is so important to actually ascertain, did you really eat? Can you understand this? Huh? So that's how cross-examination allows us to get nearer to the truth of events because of the way human beings are made. We are not very specific in the way we say things. We are reckless, we are careless in our speech and thoughts. And in the court, especially the criminal court, when we are trying to find out whether the accused is guilty or not, it is extremely important that we go through this rigmarole, this process of ascertaining whether what the witness is saying is true or not true. Now, many times, witnesses don't lie. But many times what witnesses do is they mislead unknowingly. They mislead unconsciously. Niat baik, tapi misleading. So that's the purpose of cross-examination again. Now, the next purpose of cross-examination is to test the credibility and truthful testimony of the witness. For example, let me give an example of a case that I did. It was a very simple case. It was accident case. So this witness came to court, this prosecution witness came to court and say, ya, saya pada hari Sabtu, pukul 2 petang, ada satu accident depan kedai saya. So he was supposed to be the key witness. So you're saying, yeah, there was an accident in front of his shop, and he saw that there was a car which was crashed, and there was a pedestrian on the roadside, jatuh, luka. So my turn came. So I asked you this question. You said there was an accident in front of your shop. Did you see the accident? To everybody's surprise in court, he did not see the accident. When the accident happened, he was behind the shop. He only ran out when he heard the sound. In other words, he came after the accident happened. And that's very important. Because otherwise, the testimony, the evidence would be that he actually saw the accident and my client is the one who caused the accident without any fault of the other person, who's a motorbike rider. You understand? Huh? So there we are testing the credibility of the witness. He was telling, he's not lying, but he's not credible. In his mind, he assumed that when he answered the question that there was an accident, it means that he saw. No, he didn't see. Now, the next purpose is to try to challenge someone to speak the truth. Now, this is going to be very, very difficult. Can you imagine if you have a witness that comes on the side of a prosecution? Now, obviously, when a witness comes on the side of prosecution, they're going to give evidence which is in favor of the prosecution. Or when the plaintiff brings a witness, obviously, the witness is going to support the plaintiff's version. How are you going to get from the witness what you want? How are you going to get the witness to support your side of the story? In other words, how do you make him speak the truth? It's a tough challenge. And number 6 is a means of separating truth from falsehood, of reducing exaggerated statements to the true dimensions. Now, these exaggerated statements, it happens all the time in court, especially, for example, if you take a defamation case. Now, the plaintiff will go to court and say that his entire reputation was destroyed because of the statements made in the newspaper. Now, in a defamation case, you can only be defamed if you have a reputation. I don't know whether you've done defamation finished, but anyway, in a defamation case, you can only be defamed if you have a reputation. In other words, the reputation must be established first. So if you cannot establish reputation, you cannot be defamed. But most human beings, when they feel insulted, they think that that is defamation. That is not defamation. Insult and defamation are two different things. So when you ask this question, who are you? Example, who are you? I am a school teacher. All right. Where are you teaching? I am teaching in the school Kampung Makam, for example. How many people do you know? Not many people you know. Can you compare the reputation of a school teacher who's teaching in a, say, primary school, compared to, say, a politician, a prime minister? Obviously, a prime minister will have a greater reputation than a school teacher, am I right? So the damage done to either one is very different. So the only way you can ascertain this is by cross-examination, by bringing the exaggerated statements to the correct dimension. This is a statement made against a school teacher. Okay, now before we go to the exciting part of the art of cross-examination, I have to go through with these rules of cross-examination, this boring part of principles. As I said earlier, all these principles or rules of cross-examination, you can find it in the Act. For example, you look at section 138. Now, whether you look at 138 or whether you look at anything else, you must remember at the back of your mind that all evidence that is adduced in court must be relevant evidence. That's the most important criteria. If the evidence is irrelevant, it will not be allowed. Doesn't matter whether it's cross-examination or re-examination or examination in chief. Only relevant evidence can be allowed. Therefore, Article 138, if you look at Article 138(2), it says the examination and cross-examination must relate to the relevant facts. But the cross-examination need not be confined to the facts which the witness testified. What does it mean? What this means is, a witness for the prosecution may come to court and say, he may give evidence and say, for example, it is a case of a, say, CBT, a criminal breach of trust. So he comes to court and say, yes, I am the bank officer, and this is the bank statement, and this bank statement shows that there will be money that will be coming out and coming in from the accused account. And on such a date, there was about $500,000 that went into the accused account. So that was the only evidence by the prosecution. Now, the aim of that evidence by the prosecution is to show that monies entered into the accused account. Now, the question is, must cross-examination be only confined to those questions, or can we ask something else? 138(2) says the lawyer, the defense lawyer, is during cross-examination is not confined only to the questions asked in examination in chief. He can ask something else. So going back to the bank example, one question that you can ask the bank officer is, if you have the facts, if you know, you can ask him is, how long have you been in the bank? He answers, for example, I've been with the bank for 12 years. Do you know the accused well? Yes, I know the accused well. Do you know that it is common for the accused to have a lot of money coming in and coming out? Yes. Do you know that that happens because of the nature of his business? Yes. Do you know that in a month, a sum of 1.5 million to 2 million comes into his account? Yes. Do you agree, therefore, that $500,000 is very normal for his account? Yes. So by asking these kind of questions, we're able to dilute the imputation of guilt by the prosecution onto your client. And that shows that you don't have to confine during cross to the questions which the prosecution has testified. Now, if we look at 154, it says that 154 is a very interesting thing. Sometimes what happens is a prosecution may call a witness, and that witness turns to be hostile. Suddenly you find that everything the witness is saying is supporting the accused. And that becomes a very hostile witness. Therefore, now the prosecution is caught in such a situation whereby the witness, the hostile witness, is not giving evidence in his favor, but in the favor of the defense. Now, he cannot apply to the court to turn this witness into a hostile witness, and he can now cross-examine his own witness. But remember, I told you earlier that cross-examination is only generally by the adverse party. This is an exception. So an exception of cross-examination of your own witness is when your witness turns into a hostile witness. Now you can also cross-examine somebody as to their character. That's under section 140. And the nice thing about cross-examination is that you can ask leading questions. What are leading questions? Leading questions are questions where you provide the answer. For example, in a criminal case, a prosecution adduces, brings forward his witness, He asked I'll give you a simple example for the sake of discussion. He asked a question. Okay, he wants to show to the court that on that day, his witness ate in the canteen at 10 o'clock. Okay, how does he do that? He says, 10 o'clock on Tuesday, where were you? He says, saya berada di pejabat saya. Okay. Apakah kamu buat selepas kamu berada di pejabat kamu? Saya pergi ke kantin. I went to the canteen. Right. Apakah kamu buat di kantin? Saya makan di kantin. Apakah kamu makan? Saya makan nasi lemak. You realize 5 questions for the prosecution just to adduce, to say that his witness was at the canteen at 10 o'clock eating nasi lemak. Now, reverse the same situation to the defense under cross-examination. Under cross-examination, we can lead. We can lead meaning we ask this way. Do you agree with me? Adakah awak setuju bahawa pada hari Selasa pukul 10 pagi kamu berada di kantin makan nasi lemak? Ya atau tidak? Ya. That is leading question. Hope you can follow me, yeah? All right. Now, Section 146 of the Evidence Act also tells you what are the questions which are lawful, unlawful. Now, before we proceed any further, you must always remember that in the court, the referee, the judge, has got the discretion to allow and disallow any kind of question. When I say any kind of question, it means those kind of questions which are legally can be disallowed. You know, a judge cannot use his discretion without any legal basis. Huh? So any question that is not which under the Evidence Act can be allowed, he can disallow. But you can under cross ask questions to test the credibility of a witness, the veracity of a witness, the accuracy of a witness, and how to test credibility, for example. If you can show that this is a kind of witness who's got a very poor memory, his credibility is destroyed. Or we can show that he's an incorrigible liar. He always lies. Or he gives evidence which is materially inconsistent. There are material contradictions in his evidence. So all these things are allowed under Section 146. And you can even shake his credit by injuring his character. You can say, for example, in a case, if there are such facts, that you and my client have been enemies for the past 8 years. And you can show reasons why the witness has got reasons to lie against your client. These are examples. Now, Section 146, however, is subject to Section 148. Now, sometimes it is possible for some lawyers to get carried away and to insult the witness. You're not allowed to do that. Again, as I told you earlier, under cross, the principle is that whatever question that you ask, it must be relevant to the case. And we talk about relevancy, it must be relevant to the evidence, relevant to the subject matter, relevant to the case. If it's not relevant, then it's not allowed. Because the court also has got to protect the character of the witness. Can you imagine if a lawyer keeps calling the witness, you're a liar, you're a liar, you're a liar without any basis? And then papers report it, and his credibility may be destroyed. So the courts have got to balance whether or not those questions can be asked under cross or cannot be asked under cross. Just a bit more. Now, some of the rules of cross-examination are, as I said earlier, indecent, scandalous questions. Those cannot be asked. Those are annoying questions. Similarly, also Section 152. You cannot ask insulting questions or annoying questions. Now, the other very important point in cross-examination is this. That is the technique of putting to the witness. Now, let me give you another example. Yeah? Let's say, for example, let's say a criminal case. Let's say you're defending someone charged for simple theft. Okay, theft of motorbike. Theft of motorbike, easy example. Now, your defense is that your client did not steal the motorbike. The prosecution case, for example, is that the motorbike was found in your client's housing area, in your client's, compound. House, in the compound, in the porch. So he was arrested and was charged for stealing a motorbike. Now, your defense is that he did not steal the motorbike. He doesn't even know who put the motorbike in his porch. That's your defense. So, if that's your defense, you have to put it, you have to suggest it during the prosecution case itself. Say, for example, the witness for the prosecution is the investigating officer. So he comes to court, he says, ya, pada hari tersebut kami telah menjumpa motorbike tersebut di porch tertuduh. We found it there. Then we arrested him. Anyway, other people saying blah blah. Now you must put to the IO. Number one is, now in the house, other than the accused, are there other people staying? Answer is yes. There are 3 other people staying there. Is that the house of the accused? No, he's renting a room there. Did anyone see the accused steal the motorbike? No. Okay. I'm still on air, right?
Yeah, Datuk. Yeah.
Okay, so continue.
Yeah, yeah.
Okay, I was about the motorbike, isn't it?
Yes.
Yes, I was talking about the motorbike. Okay. What was I saying? Okay, anyway, so you have to put your case to the witness during the prosecution case. Now, this becomes very, very fatal during a civil matter. Now, in a criminal matter, at least, whatever that the prosecution needs to be proved, they must prove. They must still prove the ingredients of the offense. So even if your failure to cross-examine, katakanlah lawyer tak pandai pun, what is illegal still is illegal. But that's not the same situation in a civil case. In a civil case, if you fail to cross-examine the plaintiff's witness or the other side's witness, you are deemed to have accepted the version of the other side. If you do not challenge the version of the other side, you're deemed to have accepted it. That's the law. And I've seen good cases in civil law, in the civil courts, get destroyed because of the failure to cross-examine. And you cannot blame the system because the judge is hearing this for the first time. So when you don't cross-examine on a material point, which the other side has adduced, what is the judge supposed to think? He thinks that both parties agree that that is a correct situation. Therefore, since there's no dispute, he accepts it as the real situation. So these are the basic principles. These are the basic principles and rules of the cross-examination. I think the rest I'll take under questions and answers. Now we come to the more interesting and difficult part. The earlier is all based on the rules of Evidence Act. It is really impossible for anyone to teach anyone the art of cross-examination because this is more into experience advocacy. The most important point for a good cross-examination is be completely prepared for your case. There's no such thing as being over-prepared for a case. You can never be over-prepared. That's the most important thing, meaning you must know your case in and out. In fact, you must know your case in such a way that if you go for a criminal case, you must be able to predict what is the angle of the prosecution. You must be able to at least predict in your head what is the purpose of each of the witnesses. And nowadays, they give 51A documents, meaning the documents that the prosecution intends to rely on in the trial, they will pass it to the defense. So you must look through every single shred of those documents to find out what is the purpose of these documents, because you don't want to be surprised. So the first key point which I always emphasize is, when you go to court to cross-examine, before you open your mouth, know why you open it. Know the purpose of the question you are asking for. Why do you ask? Do you want information from the person? Or do you want the witness to declare something? Or do you want to impeach him? Impeach him meaning to say that his evidence is not credible. You must know your purpose in your head. You cannot go to court and say, tak apalah tanya tengok macam apa jadi. You cannot do that. If you do that, you're fried, your client is fried. The second point is, who is the witness? You must know who you are cross-examining. Now, there are two kinds of witnesses generally. You have the lay witness meaning the ordinary witnesses, and then you have the expert witness. He may be a chemist, or he may be a doctor, or he may be somebody who's with the road transport, depending on the nature of the case, expert. Or thirdly, he may be a key, very important. He's not an expert witness. He's a lay witness, but he's a very key witness. For example, an eyewitness in a murder trial. He says, I saw the murder. I saw. Then is he a corroborative witness? Corroborative witness means someone who supports another witness. Yeah, I was there together with Azmin. Yeah, I saw Azmin do this. Or is he a formal witness? Formal witness is a witness, for example, like a bank officer. He just comes to court only to adduce bank statements. Or he comes from a SSN, Suruhanjaya Syarikat Malaysia, just to adduce relevant formal documents. So you must know who these witnesses are, because different witnesses have got different ways of cross-examining them. So if you know that you're going to be faced up with an expert witness, then you ought to be prepared in that area. I always tell lawyers that if you are going to cross-examine a chemist, you must be as good as a chemist. For that case, you learn as much as possible about that relevant aspect of the chemist report. If it's for the water pollution, you'll be as good or better than the person who's an expert in water pollution. I mean, that's an interesting perk about being a litigation lawyer, but that's a different point. So each of these different witnesses have got different ways of being cross-examined. Thirdly is, keep to the level of the witness. That is very important. I have seen some lawyers lose their temper unnecessarily with a very slow-minded witness. Now, human beings, not everybody has got same level of cognitive abilities. Some are clever, some are not so clever. Some have got higher degree of being able to face stress. Some got very low levels of facing stress. So we cannot expect everybody to be able to think as fast as or as deep as us, the lawyer. So you must know your witness, because if you have a witness who is slow-minded, if you ask him questions bertubi-tubi, you will make him, you will freeze him, unless that's your purpose. Unless your purpose is to freeze him, don't do that. Because if he gets frozen, then there'll be no evidence. But I say, unless it's your purpose. And the personality of the witness. Now, personality meaning, what was he? Now, to give an example, to make you understand, I had in one case a general who came as the witness for the prosecution. When I saw the general, I said, "Alamak," because he sits up straight like that. He's so used to giving commands, and when he was giving his evidence during the prosecution time, he was talking very authoritatively, and I can see that even the prosecution was a bit worried with him. So I said, this is going to be a very difficult witness to cross-examine. The ego is very high. So I had to take a gamble. So when he came on stand during my time, I stood up and said, "General, will I be wrong or right to say that you're a very arrogant man?" So that really rattled him. So I took a risk. So the court even looked at me and said, "No, I need to know, are you arrogant or not arrogant?" Of course, he said, "I'm not arrogant." Then I said, "Then I suppose you will be afraid to tell the truth." So while he was giving his evidence, I had to say again and again, "Why are you scared to tell the truth?" And he started blurting everything out. So what I was doing there was, I was taking a gamble. I saw the personality of this person is egoistic. I have to poke his ego, I wasn't being bad. I have to do that so that I can get the truth out. This is what I'm saying. Cross-examination is the art of getting what you want from the witness. Cross-examination is the art of getting the truth out of people in a way the persons don't realize. That is the art of cross-examination. It's tough. Now, number 4, this is something a lot of junior lawyers make a mistake, and some lawyers who want to impress their client make a mistake. Do not be in love with your own voice. You must know when to stop. I know that in court, some junior lawyers go to court and they're very excited and they're able to ask 1,001 questions. In fact, sometimes some of the best cross-examination are only 4 questions. Only 4. And sometimes there's so much cross-examination, you know that the lawyer is only trying to impress the client. Now, let me give an example of this. There was a case whereby this person was charged for murder of somebody and for biting the tongue of the deceased. So prosecution called a witness. Let's call him Ali. So Ali came to court, spoke a lot of things, and finally he said that tertuduhlah yang telah gigit lidah si mati. Then the cross-examination, then the defense lawyer stood up. He asked so many questions. One of the questions he asked is, he said, "Do you agree that when the fight took place, you were not there?" He said, "Yes, I agree." "Do you agree that when you arrived at the place where the fight took place, the deceased was already down and dead. Yes, I agree. Therefore, how can you say that it was my client, the accused, that bite his tongue? And the witness said, I did not see him bite, but when I was there, I saw him throw out the tongue of the deceased from his own mouth. So that was one question too many. So because of the defense lawyer, now it is established that it was his client who actually bite the tongue of the deceased. Now, number 5 is, if you do not know the answer, do not ask. Do not take a gamble if you do not know what is the answer that the witness is going to give. Number 6, do not quarrel with the witness. You must understand, when you go to court, a court lawyer is not only a lawyer, he's also a drama artist. When in court, if you are angry, it is because you want to give the appearance of being angry. In other words, you do not get angry unless you decide to be angry. So the general principle is you never quarrel with the witness, because the witness is the witness. You are the lawyer there trying to elicit evidence. If you quarrel with the witness, then you bring yourself down to the level of the witness and you will lose your momentum, and more likely than not, if the witness is important, you lose your case. Number 7 is lead the witness to give the answer you want. Don't go to court and ask questions. No, pada hari itu kamu buat apa? Adakah kamu lihat motorbike itu? You say, saya cadangkan kamu tak lihat. Betul tak tidak? You tell him. You ask him, agree, disagree, agree, disagree. You want to lead the witness to give the answer you want. Of course, before you can lead the witness to give the answer you want, you must know 2 things. You must know who is the witness, what is the evidence he's giving, and number 2 is, what is the answer that you want? Number 8, never ask long questions. Number 1, if you ask long questions, you confuse the witness. Number 2, usually very long questions are asked by lawyers who don't know the case. So if you've got a long question, break them up into smaller questions. Number 9, expert witnesses. Now, this is another fatal area. Yeah? And depending on what case it is. Say, for example, it is a case of drugs. Now, in the case of drugs, there are certain requirements that the expert witness must comply with. You are the defense lawyer. It is a job of the prosecution to ensure that the expert witness complies with all those that are required to be complied under the law for the prosecution to prove his case. As a defense lawyer, you are under no obligation to ask all the kind of questions which will fill up the gap of the prosecution's case. So resist the temptation to look and sound very clever, but actually you're burying your client's interest. So as an expert witness, do not do the prosecution's job. Next, there are many questions. This one, practicing lawyers will appreciate and understand. You will understand one day when you come to practice. There are many points, there are many things in the case where you can reserve for submissions on legal points, which you don't even have to cross during the trial. The other one is expert evidence, chain of evidence. Very important. Whenever any expert comes to court and you find that there's no chain of evidence. What is chain of evidence? Chain of evidence means I went to UIA and to give a parcel to Dr. Ismail. And Dr. Ismail took the parcel and gave to Miss Moderator. That is the chain of evidence of the movement of the parcel from me to Dr. Ismail to Miss Moderator. Say, for example, that parcel is very important. And the only evidence given in court is that I gave the parcel to Dr. Ismail. And there's no evidence in court to say that Dr. Ismail gave the parcel to Miss Moderator. During cross, after order is over, if I ask the question, you say somebody asked the question, did I give the parcel to Dr. Ismail? That means I am doing the prosecution's job. Without that evidence that Dr. Ismail gave the parcel to Miss Moderator, the case will collapse. If that parcel is very important. Why? Because the chain of evidence must be given. So during cross, you must understand, you must see, is the chain of evidence established? Do you want to show that the chain of evidence is not established if it's unclear? If it is clear that the chain of evidence is not established, don't cross. Don't even ask anything. Just sit down. Now, expert evidence. Now, expert evidence, depending on the expert, every expert must have credentials. So you may want to attack his credibility or credentials if the credentials are given. In a criminal case, what happens if the credentials are not given? The question you could ask is it my job or is it the prosecution's job? The answer is, it is a prosecution's job. So why do you want to do a prosecution's job for? But on the other hand, if the evidence of his credentials have been given, then you want to attack on his credentials. For example, you can ask a question, you've been a chemist for 10 years, is that correct? Yes. You have given evidence in court, is that correct? Yes. You have given evidence in court for 25 times, is that correct? Yes. Do you agree that out of the 25 times that you gave evidence in court, only twice the court has accepted? He will take a long time and say yes, very quietly. So you've established that his evidence is not so credible. 13, I already mentioned earlier, you must know the rules of the evidence. 14 is very important. You must know the ingredients of the charge. Okay, what do you mean by just very briefly? Yeah. Let's say I'm charged for stealing a motorbike. So the charge for stealing a motorbike must be, number one, the ingredient is that there's a motorbike. Number two is that there's actus reus and mens reus. I think you studied this. Yeah? Actus reus and mens reus. There's an intention to steal and there's an act of stealing. Those are the ingredients of the charge. So when you conduct a cross-examination, you want to conduct your cross-examination in a way to show that the ingredients of the offense, the ingredients of the charge has not been proven. Now, this is a very key point for any practicing lawyer. Now, fifthly is circumstantial evidence. Now, many times there are cases where you cannot find direct evidence. Nobody saw the person being murdered. Nobody actually was there, but the circumstances may show that the person was murdered. Nobody saw the motorbike being stolen, but the circumstances may show that it's being stolen. So here, under circumstantial evidence, the art is to throw doubts onto the circumstances, whether the circumstances add up together to point to the guilt of the accused or not. Next is cross-examination of a person to produce evidence. Now, this is very important. Now, it is often forgotten. When you speak about oral evidence, people remember, oral evidence must be direct evidence, not hearsay evidence. But many people, including some junior lawyers, forget that even documentary evidence can be hearsay evidence. Meaning what is contained in the document could be hearsay. So if oral hearsay is not allowed, then documentary hearsay also cannot be allowed. Therefore, questions need to be put, the witness need to be crossed onto the contents of the document to establish whether or not those contents are direct evidence or circumstantial evidence. That's it. Have I finished too fast? Miss Moderator?
Thank you, Datuk.
Hello?
Hello? Thank you, Datuk.
Hello.
Can you hear me?
Doc.
Hello?
Yeah, Datuk. Yeah.
Have I finished too fast?
No, it's okay.
Okay.
So at least I can reserve for question and answer. Right?
Yeah, that's true.
So we open
Okay,
for...
maybe Miss Moderator is having a network problem.
Okay.
Because just now she informed me that she having a problem.
As you know, Doctor.
Yeah.
I've just delivered in 1 hour, is it?
Yeah.
1 hour, which is one semester.
Yeah. 3:30, yes. We start at 2:30, 3:30, just nice.
Yeah.
Okay, everyone can hear me? So we open for